Okay, we'll go back on the record. Ms. Thompson, you're ready to proceed?
Thank you, Your Honor. Your Honor, Todd Mullis has spoken the truth in this case from day one. He said this was an accident. He asked his attorneys to investigate it as an accident. He gave multiple consistent interviews. He testified at trial. He testified at child guardianship proceedings that are part of the record below from his motion for a new trial. He filed this PCR, a verified PCR. He provided affidavits. His belief has been consistent and has never wavered that this is an accident, that he was in no way involved, and that he wanted his counsel to pursue that issue for him. That's different from other witnesses who testified at this proceeding and whose stories have changed over time. There's nothing that Todd Mullis could have said to this court that he hasn't said before. And that's why this post-conviction hearing has been about all of the evidence that should have been presented at trial to support what he's been saying all along. The court has pointed out that this is an evidentiary hearing, that all of the evidence this court is going to consider is not evidence this court heard in court during the last 6 days. Because as we just went through, the court will have depositions, the court will have documentary evidence, the court will have other evidence from the underlying record that wasn't part of what the court heard, specifically in testimony and at this hearing. But all of that together demonstrates that Todd Mullis's trial was fundamentally unfair, that the system broke down, that he did not receive the fair trial that he deserves. And that is the outcome that Mr. Mullis is asking this court to assist with now. This court really can't think about what Mr. Mullis's claims mean without thinking about what it is that actually happened at his trial. What happened at his trial was that everyone, his own counsel, the state, told this jury that Ms. Mullis's death was a murder. His own counsel agreed in opening statements that Ms. Mullis was murdered, and that belief was allowed to be presented to the jury with zero adversarial testing. I mean, this was the quote-unquote strategy that his counsel pursued at trial. Their strategy was, we're going to concede it's a murder. That's a strategy they reached on the fly, which we'll talk about in a second. And as Mr. Firehelm told this court when he testified here, Todd's going to explain it. Todd will explain all of the evidence, and that is the way that they provided counsel to him through this trial. Their strategy was Todd is going to explain the text messages. Todd is going to explain whether he knew about Ms. Mullis's affair with Mr. Frazier. Todd is going to explain the Google searches. Todd is going to explain the state of his marriage. Todd is going to explain what was happening in this argument between his wife and his mother. Todd's going to explain these hearsay statements from these witnesses. Todd is going to explain without any notice or understanding that he even needed to prepare to think about or testify about this 911 call and what he said and who was there and what he was thinking when he was frantically providing aid to his wife as she was dying. Todd's going to explain the state's circumstantial evidence that is meant to show that he was guilty. And that in effect became a trial where counsel is telling the jury, even though I told you in opening statements that Todd was wrong, believe him that he's not guilty. That is not a reasonable strategy. It's simply not a reasonable strategy, and it and all of the errors that combined cumulatively to deny him a fair trial denied him a fair trial. There are two Sixth Amendment claims that Mr. Mullis has in this case, and they're different. We talked about these at summary judgment, but I want to talk briefly about them now. One is the Sixth Amendment claim that Todd has the right to be the master of his own defense. And we spent a lot of time on that claim at this hearing, hearing from various witnesses. And I know the court has the law on this that we provided at summary judgment. The law is that Mr. Mullis has to explicitly consent in opening statements, or has to explicitly consent to his counsel conceding his guilt in the trial. He has to explicitly consent if that's the strategy. And from all of the testimony the court heard, from Mr. Firehelm, from Mr. Sabers' deposition that the court will read, from all of Todd's letters and his testimony at the child guardianship proceedings that are in the record, that simply never happened. Todd, this resulted in a situation where his trial counsel conceded his guilt because he told the jury that Amy Mullis was murdered in a situation where the lawyers were going to provide no evidence to establish that that was not Todd Mullis. The evidence is undisputed that Todd Mullis didn't know his counsel was going to do that. The court has Mr. Sabers' deposition, who testified at a deposition, and the court can review this, that he was surprised at opening statements. He was surprised to hear that that was the position the defense was going to take, that Mr. Mullis was surprised. The court has all of his letters. The court has heard from Lynn White. The court will be able to review Todd's testimony in these child custody proceedings. Todd said he never gave counsel permission to do that. All of his letters support that that's not what he understood the strategy was going to be. Mr. Sabers didn't know that was going to be the strategy. That happened without his permission. And we explained already why that's important, because if that happened without his permission, then this isn't a matter of prejudice. It's not a matter of establishing what the outcome would have been if counsel followed a different strategy. That is just a Sixth Amendment violation, period, that really ends the analysis. And on that basis alone, Mr. Mullis receives a new trial. But that's not the only aspect of Sixth Amendment. That's not the only aspect of a Sixth Amendment violation that is present here. We have a more typical ineffective assistance of counsel claim too. And this is very important because in this case, there is no reason, and the court heard no reason from Mr. Firehelm, there is no reason in Mr. Sabers' deposition to explain why it would have been reasonable for trial counsel not to investigate and present evidence that corroborated everything that Mr. Mullis testified to at trial. To investigate and present evidence about medicine, about the electronic evidence, about these Google searches that we've been talking about text messages, about the cameras. There is no reasonable strategy that would have allowed counsel to not pursue any of this evidence, and instead to pursue what they did at trial, which is to concede this was a murder and to let Todd explain himself unaided to the jury. What's important about this, and what we want to make sure the court understands, is that even though in this evidentiary hearing, the applicant has spent a lot of time presenting evidence to the court and proving to the court that Mr. Mullis didn't agree with counsel's strategy, even if Todd Mullis never wrote a single letter to his lawyer, even if he was maybe a person with a little less understanding about the way that biomechanics work, his instincts about what might be true, even if we had none of these letters, even if we didn't have the vast record we have here that Mr. Mullis was asking about these issues, that he wanted this to be investigated, that he was seeking investigation, that he consistently and unwaveringly believed that his wife's death was an accident, even if none of that was true, and Todd Mullis had just said to his lawyers, give me the best defense you can, I don't know what happened, but do your best. If that's all he ever said, counsel would have still been ineffective. It is not Todd Mullis' job to have told counsel what the right strategy was here. As it so happens, he did. But even if he didn't, it doesn't matter, because there's no reason not to investigate these issues. This is not dependent on what Todd Mullis agreed to or not. It is ineffective for counsel to have chosen the path that they chose, and that is because they chose it without a reasonable investigation. We cited law to the court in our summary judgment briefings, and we will cite more law. The United States versus Hinton, the United States Supreme Court has said that it is ineffective for counsel not to understand science and not to get experts in a case where expertise is required. And, Your Honor, this is such a case. This was clearly a medical case. Mr. Firehelm told you, I relied on my own understanding about this. You know, I was first chair. I made these decisions. I relied on my own understanding to decide that there wasn't anything I needed to pursue there. Under Hinton, under the other law that we've cited to the court and that we will cite, that's ineffective. The state may point out when it speaks to the court that in his deposition, Mr. Sabers did describe, as the second chair, as the person who was not making decisions in this case, some of the things that he tried to do, because he did try to do more than Mr. Firehelm did. For instance, he himself went to the shed. He looked at these augers, and he talked about that in his deposition. He also read the case materials, like Mr. Firehelm did. But there's no evidence that Mr. Sabers discussed these issues with Mr. Firehelm other than telling him that he'd visited the shed and looked at these augers. And there's no evidence that Mr. Firehelm did anything that Mr. Sabers asked him to do. The state's own exhibits show this, that there is a email from Mr. Sabers to Mr. Firehelm where they discuss we probably should get an expert. I mean, they knew that Todd was asking them to do that. They agreed they probably should get an expert, and that just didn't happen here. They never provided case materials to an expert, either a pathologist or a biomechanical expert who could explain to them that there was a defense here, a reasonable defense that they should have followed. They just didn't do that. And Mr. Sabers, doing his best to look at a couple of things, to give advice to Mr. Firehome that he never followed, that's not a strategy, that's not a decision, that's failing to do what you know you should do. And there's no reason that the state is going to be able to articulate for not following the only reasonable strategy here. That leaves us with the question of what this trial would have been, the prejudice issue of Strickland, if Todd Mullis hadn't been standing alone at his trial without any of the assistance that his counsel was supposed to provide him. If his lawyer wasn't just saying, trust Todd, what would the jury have heard? And at the end of this hearing, especially hearing the evidence the court's heard here in court, considering the other materials as well, the court knows the answer to that. The court knows that if this had been a fair trial with effective assistance, this jury would have heard that this was not a murder. And it would have heard that from sources that are far more credible than the state's witness who testified at trial without any cross-examination, save one question, that this was a murder. This was a medical case. And the court heard extensively, and I know we spent a lot of the court's time making sure that the court could hear the opinions of Dr. Cruz, the opinions of Dr. Hammers, the opinions of Dr. Nye, to decide what the true state of the medicine is. And based on that testimony, there's really no question what the state of the medicine is. This is not a murder. This is not a homicide. This is an accident. Dr. Hammers was able to talk about that from a pathology perspective and explain why, despite there being unopposed testimony offered at trial that Ms. Mullis had defensive wounds, that there was nothing about the state of her body or this autopsy that indicated that she was the victim of a homicide, but that this was an accident from a pathology perspective. The court knows that Dr. Cruz said that she couldn't really figure out how this happened. She just couldn't see any reason that it was an accident, and that is essentially why she determined this was a murder. After 2 to 3 hours of doing this autopsy with other autopsies, she came to that decision, she stuck with it, and she made that decision without the benefit of any biomechanical testimony, any biomechanical advice or assistance. The court has that assistance now from Dr. Nye. Dr. Nye started looking at this case to review the opinions of others, and we're not asking the court to even consider that piece of what she did, because she then went on to do her own investigation. She did her own visit to this scene. She did her own consideration of the wound pattern. She did her own force calculations. The court has her math on her notes where she went through and actually figured this out, figured out the force that would have been required to fall from a standing height, from a kneeling height, figured out the force that would have been required and the direction of the force that would have been required for this to have happened in different ways. And from that biomechanical evaluation, she told the court that the only hypothesis that she can't disprove is that this was an accident. And there is no other biomechanical evidence before this court. If the state wanted to call a biomechanical engineer, or really any witness, to say that Dr. Nye was wrong, they could have done that. That's not what they did. Dr. Nye testified without any opposition. Dr. Cruz said, I really can't speak to those issues. And that's testimony the court has to consider in deciding what the state of the evidence is here. I'll go through the other evidence the court heard briefly, because the medical evidence is the most important. The court heard that despite at trial the unrebutted testimony, save from Mr. Mullis, was that all these searches were from the iPad and that they were very nefarious. And when the court actually gets a chance to see that those searches didn't come from the iPad, that many of them came from other devices, and the actual content of the search, that these searches are related to hunting tests, they're related to television programs. The actual content of the searches and the evidence that they didn't come from the iPad tells you that Todd's testimony was right. The court will have a chance to look at all of these texts and emails which are in evidence, and the court heard from Mr. Seferik and others about what all of this electronic evidence means. And it proves what Todd said, which is that even though his wife was having an affair, this had not bled over into the marriage, that he didn't know about it, that they were living relatively happily, despite the fact that there were sometimes, disputes with a mother-in-law. None of this was creating this situation that resulted in some planning to end someone's wife's life. I mean, there are text messages with Todd right up until the end of Ms. Mullis's life where she's saying, I love you. The court has Tristan's testimony, and it should evaluate it, that Tristan has explained why he testified as he did and that his dad was really only out of his sight for a short time. The court knows about the 911 call. It heard a lot about that, about the discovery violation that occurred there, and that this was a trial by ambush with respect to this 911 call, and that 911 call is not what the state described, and that Todd was with other people, sheriffs, when that happened. There's a lot of other claims that counsel presented, and the court knows what the evidence about that is. Based on the evidence the court has, it knows that Todd's established his Sixth Amendment claims, it knows he's established an actual innocence claim, and that this is the rare case where, considering these claims separately or cumulatively, that a new trial is really the only fair outcome. I'm going to come back and talk in rebuttal in a minute, but based on what the court's heard, there's no doubt that Mr. Mullis's trial was unfair, and there's just one result from that, Your Honor, which is a new trial.
Thank you, Ms. Thompson. Closing argument on behalf of the state.
Thank you, Your Honor. May it please the court. Good afternoon. I will be brief. The state submits that Mr. Mullis has not met his burden of proof on any of his claims. We ask the court to deny his application in its entirety. In addition to the record and issues that have already been developed at trial and before it in this proceeding, we will address our legal reasoning for why each of his claims fail in our written brief. Thank you.
Thank you, counsel. Your final rebuttal.
I just want to add one more thing, which is that although we believe that we've established Mr. Mullis's actual innocence, which means that there should not be any new trial, if the state concludes that they want to rely on Dr. Cruz and retry him, that's an opportunity that he should have an opportunity to present this evidence to the jury. Because the last thing I'll say about this is the court may conclude, in looking at all of the evidence, both what it heard here, what it reads in the record, and it may determine, well, I see some evidence on the other side. You know, I see some evidence still that for me, I don't know what to make of that. I see that there, you know, the state made some arguments at the original trial, and for me, I don't know where I end up on actual innocence. The court can have questions as a result of this hearing about what happened, but as the court knows, those questions are the province of the jury. It is for the jury to decide if it believes Mr. Mullis. It's for the jury to decide if it believes this other evidence. But this is all evidence that the jury should hear. Because Mr. Mullis has established there is at least a reasonable likelihood that the outcome of this trial would have been different, with the overwhelming evidence that the court has seen, that it has read and will read, that it's heard. This is evidence of an innocent man. This is evidence of a man that deserves a new trial and a trial where he can have his day in court. And for that reason, Your Honor, we're asking the court to grant Mr. Mullis a new trial, and we'll provide additional legal briefing in the post-trial briefing that we make in a month, Your Honor. Thank you.
Thank you, counsel. I will await both parties' final briefing by the April date that we previously discussed. At that point, I will consider the matter finally submitted. Counsel, if you maybe just want to touch base with me briefly in chambers before you leave so that we can make sure that everybody is on the same page as far as the exhibits that were admitted. And then I'll give you a day or two just to review any final security level issues before I file the exhibit management order. Other than that, anything that we need to address before we go off the record? Anything on behalf of the applicant?
No, Your Honor.
Okay. Anything on behalf of the state? No, Your Honor. All right. Thank you all for appearing and for your cooperation to keep things moving throughout the trial these past days. Thank you.